Well, hey, authors, welcome back to another of our Experts for Authors interviews. Today, we are talking to the fabulous Michelle Mozdzen, and she is a professional lawyer. I'm so excited because we actually know each other outside of the professional world as well. But introduce yourself to everybody and let us know what it is that you do.
Hi, everyone. My name is Michelle Mozdzen. I'm an attorney at May Potenza, Barron & Gillespie, based in Phoenix, Arizona. And I specialize primarily in intellectual property law. I also do mergers and acquisitions, business transactions, contract drafting, and civil litigation. I also have a background in doing criminal defense. I worked criminal defense and administrative law for the first 5 years of my legal profession. So I've got some pretty broad experience across the board that hopefully I can be a resource to you with whatever kind of legal scenarios your characters or stories are facing.
Inside of your stories. So just quick disclaimer, Michelle is not your lawyer. Michelle, what do they need to know?
That's right. So I'm happy to talk to everyone about the different situations and that you might be writing about and help you portray your situations most accurately. But please know that I am not your attorney. I am not giving you particular legal advice as to any kind of a situation. This communication, this live stream does not create an attorney-client relationship, and none of what I'm saying here or what we're talking about today is going to be privileged. So with all of that in mind, let's get started.
I'm so excited for this. So let's talk a little bit about job specifications. So what does it take to be a lawyer?
So there's no particular degree that is required for undergraduates to be an attorney. Basically, you go through your undergraduate degree. As long as you have a Bachelor of Arts or a Bachelor of Science, you can apply to law school. So then you take the LSAT, which is you take the LSAT and then you submit your applications to law school and you get in, then you get your Juris Doctorate after everything is assuming you pass law school and graduate just fine. Now there's an additional degree that you can pursue after your JD, which is the LLM. And so that's sort of like the master's degree of law school. So that's an additional year. That is a 4-year program. Law school, getting your JD, is typically a 3-year program.
Okay, that's really interesting. I did not realize that. I'm learning things already, which is fantastic. And if you're joining us,
sorry, let me just finish up real quick with that. So after you graduate law school, then you also have to pass a bar exam, which is required to be able to practice law in any given state or jurisdiction across the United States. So you have to pass the bar exam. There's also a character and fitness examination that you have to go through as well. And that just sort of makes sure that you are up to the moral and ethical standards that state bars like to license people with. So
that makes a lot of sense. If you're joining us live and you have questions, go ahead and drop those right now. If you're on the replay, we will try to get back to you with answers on that. So please feel free to leave those in there. And Michelle, I want to talk a little bit about that moral and ethics overview that we were just mentioning. So what does that look like when you have to kind of do that? Is that like an interview process? What does that look like?
It's basically a questionnaire that they submit. They want to know all kinds of different things about your background, about your debts, about any sort of criminal encounters that you may have had, financial obligations, things of that nature. The attorney profession, despite the reputation that we are often portrayed in, media, it's one of the most highly regulated industries of professionals out there. We have ethical rules that we are required to adhere to. And if we fail to adhere to those ethical rules, not only can we be fined and sanctioned by the court with monetary penalties, we can also have our license to practice law rescinded or restricted.
Interesting. So what does that look like if it is restricted? Does that mean you can't do certain things or within certain locations? What is that?
It would basically mean if there was an attorney who was found to have engaged in unethical practice of some sort, they may be restricted from practicing law for a certain period of time, or they may be required to go above and beyond with some sort of receivership or something set up if they need some additional supervision as determined by the state bar in their jurisdiction.
Okay,
But
interesting.
Fortunately, we don't deal with that too often.
Always a good thing, but I feel like as authors, that's one of those things that we would want to know about.
Right, absolutely.
Always writing in those little interesting things. Speaking of which, we're going to get to what the entertainment industry gets right and wrong within the legal profession in just a minute. But I want to talk a little bit more about what a typical day looks like for you. So we know how you get into law, but once you're there, what does this look like?
So my typical days, it varies because I practice in intellectual property law, and I also do civil litigation and business transactions. I'm all across the board with with this. So some days it'll be drafting trademark applications. Other days it will be going out to meet with my clients to look at their services, look at their products, and get to know their brand, because the better I understand my client's business and the better I am at communicating that, the better I can represent them and give them the full protection that their business and their intellectual property needs. So other days it's reading and responding and analyzing different briefs or motions that are filed in civil litigation. Other days it's reviewing and drafting contracts or negotiating a business transaction.
One of the things that I like to talk about a lot in these interviews is the paperwork that comes with different jobs and occupations. And I know for you, you get a lot of them. So what types of paperwork do you typically do? I know you mentioned contracts and things like that. What does it look like?
Yeah, so there's a lot. And again, it's all kind of specific as to what we're talking about. But what we might be interested in, let's start with civil litigation. So any document that's filed with the court is called a pleading. It's on pleadings paper. It's numbered on the side of the margins, usually lines 1 through 26. The purpose of this is because, well, a lot of judges are old. They like to save their eyes. So they like things to be big and well spaced. But it also helps the parties if we want to refer to something specific, we can say it was on this page, this line. It helps for referencing as well. Mm-hmm. So anything that is on pleadings paper and is filed with the court is considered a pleading. Now, a civil complaint or a civil lawsuit is going to get initiated with several filings in the very beginning of the case. And this is what you need in order to initiate a civil lawsuit. First, you're going to have your complaint. And that basically lays out the factual basis and the legal basis for the claims that you are asserting against the party. So you, as the person asserting the claim, are going to be the plaintiff. The person against whom you are asserting those claims is the defendant. So it can be a person, it can be a business, it can be a trust, it can be, any kind of a legal entity that has standing, can be either a plaintiff or a defendant in a lawsuit. So you have your complaint, then you have a summons, which basically tells the party you are being summoned to court to respond. Pay attention to your deadlines. You have deadlines to respond. Then after that, there's also a civil cover sheet which needs to be filed with the court, and that basically tells us, it gives the court, it's for administrative purposes primarily for them, but it's still one of those details that, at least in our jurisdiction, and I think in most jurisdictions around the country, is going to be a necessity for filing. It just kind of asks the parties to categorize what type of lawsuit it falls into so they can have that for their own records. Finally, you also need, at least in Arizona, this may not be the case in other states too, there's another certificate of compulsory arbitration. What that basically means is that Arizona, in an effort to mitigate the strain on the court systems, because it's expensive, it's costly, it's time consuming, and it takes a lot of public resources for a case to be filed in court and make it all the way to trial. So when the court can, if it's a low dollar amount case, and again, it depends on your jurisdiction. In Arizona, we're looking at under $50,000. It is subject to compulsory arbitration, which means a judge doesn't want to see your case. You're going to arbitration with another party. So a lot of these, and that's something that might be of interest to your authors too, is that a lot of these cases where it's going to be a smaller dollar value, like under 50,000, you're probably not even getting to a jury. So it would be very strange to have a jury trial for a lower dollar value amount case. And in fact, while we're on this tangent, if you're under $10,000 in damages, you're probably going to be in small claims court. And in small claims court, you're not even going to be allowed to have attorneys involved. So yeah, small claims court is completely, it's intended to allow the parties to resolve small dollar value claims, because typically you're not even filing and drafting a complaint and getting through, a round or two of pretrial discovery for under $20,000. Okay. So at that point, it doesn't really make a lot of sense for someone who's been harmed in the amount of maybe $7,000 to go hire an attorney when it's going to cost them more money to hire their lawyer than what they've been harmed in the first place. But that doesn't mean that justice still shouldn't be done, or that that person shouldn't have an equitable remedy at law. It just means that the system that's set up for them is a little bit different, and it's intended to keep costs down. So in small claims court, a judge is going to be a lot more accommodating and a lot more understanding, and may actually end up helping the parties a little bit, depending on the nature of the case. And help, I mean, they may propose or suggest or draw analogies to certain legal theories or defenses that the parties may not necessarily have asserted, but the judge is trying to find a way, they're trying to find their way to the truth and to an equitable resolution. So you get a little bit more involvement with that in small claims court, whereas the judges in your other courts are going to be much more neutral arbitrators and triers of fact.
That makes a lot of sense. Okay, I like that. Anything else we need to know, like paperwork-wise, before we jump into the next question?
Oh, goodness. Well, there's a lot of paperwork in civil litigation. And going on to that, so what happens after you file a complaint, right? Now we enter what's called the discovery process. And what happens then is that's the phase of the case where the parties are trying to obtain documents and obtain information in order to either support or defend the claims against them. So this is the phase where we issue written discovery, and written discovery can include what they call uniform interrogatories. It basically means that there's a pre-prepared list of questions, like, it can be anything from, identify your full formal name that you transact business by, what's your date of birth, have you gone by any other names, are you married, what's your spouse's name, what's your things like that are kind of standard that you might want to know to make sure that you're suing the right party. Other times you can get into what they call non-uniform interrogatories, and those are written questions to the defendants or defendant that basically, it can be anything you want, as long as it's reasonably related to the discovery of admissible evidence in the lawsuit. So you can object to those. You can say, I think it's overbroad. I don't think it's going to lead to relevant evidence. So you can certainly, object to those things, but that's how discovery is conducted. There's also requests for production if there are documents that you think that you want, and requests for admission, which if you want the party to admit, like say you've got a contract in dispute, and you would submit like a request for admission to the other party saying, admit that you entered into a contract, admit the contract is valid, admit you agreed to do this. And, what it can be used to do is to help sort of narrow the scope of litigation and help the attorneys and the parties identify what's truly at issue and what the parties can agree on to be able to maximize judicial economy, basically. So you issue written discovery to parties. If there is information you want from a non-party, you would issue a subpoena. So that's a distinction that I see sort of tying into what does the media get wrong a lot.
Yeah.
Subpoenas don't get issued to defendants. Subpoenas get issued to third-party entities that aren't a part of the litigation. So if you're a defendant or a party to the case, you're getting served with written discovery requests, but not a subpoena.
Huh. I did not know that. So that is very valuable information.
And I guess if you want, I can continue to sort of tie in to sort of walk us through this whole civil litigation analogy, because, you know, I can kind of identify some of the things that the media gets wrong, not only in civil litigation, but also in criminal trials. So during the discovery phase, you're required to disclose certain documents to the other side. If you have information that's in your possession that's relevant, there are disclosure rules that say you need to give it to the other side. And similarly for them, they have to give it to you. What this is intended to do is eliminate what they call trial by ambush, which sounds juicy. We all love the idea of it. That they were there and they come in with this outrageous claim that saves the day. But unfortunately, it doesn't work like that, because if you haven't disclosed that witness, you haven't disclosed that testimony, guess what? You're not getting to use them at trial.
Oh, no. So that's like a hard no then. Okay.
Right. The judges will, there are discovery cutoffs. And a lot of times the parties are allowed to depose witnesses. After they are disclosed to the other side, they say, hey, I'm going to call these witnesses at trial. This is our plan. The other side has the ability to depose each of those witnesses, which means that they get a presumptive 4-hour limit to sit down with them, talk to them, ask them any questions they want to about the subject matter of the litigation. So again, not only is it really unrealistic to be seeing surprise witnesses coming in, or even surprise documents coming in at trial, most likely the attorneys have already talked to this individual. So I think what would be a little bit more of a realistic, surprising turn of events would be if the individual had said something in their deposition, which is sworn under oath, under penalty of perjury, and then decides to change their story on the witness stand at trial. So,
okay.
you know, then, you know, you have the dramatic effect of having, you know, a written transcript that you can confront them with and say, well, what changed? Why are you, you know, were you lying then or were you lying now? You know, these these kind of things. So it's, but yeah, hardly ever is there any sort of surprise witness, surprise document, surprise testimony like that. Because the courts think that it is prejudicial to the other side not to be able to fully prepare to cross-examine or, you know, do their due diligence and discovery related to that witness.
Interesting. Okay, so then when you actually get to talk to them beforehand and you've got that transcript, does everybody have access to that transcript, or just the person who did it?
So everyone has access to it. There's always going to be, or there should be, best practice tip, there should always be a court reporter present if you're going through a deposition. The court reporter is going to make a record of all of the questions. They're going to swear your witness in, and they're the ones who are making an official record. And they also have ethical standards that they need to say, this is my true and accurate transcript of everything to the best of my ability that I heard and recorded on this day. So that is a transcript that can be purchased and made available to all of the parties. It's not secret, doesn't belong to any one person, but you do have to buy it from the court reporter.
Now that's really interesting. I didn't realize that was something you would have to purchase.
Okay. Yes, there are a lot of financial barriers to engaging in civil litigation. Like I mentioned earlier, you're probably not getting through your first phase of discovery for anything less than $20,000. Filing fees cost in Arizona, it's about $350 to start a new lawsuit. Depositions are also expensive. It takes time to prepare, it takes time to conduct, and then you also have the transcript from the court reporter that you need to purchase, which can be anywhere from, you know, $300 to $1,000, depending on the length and extent of the transcript.
So is that by the length and extent of it, or does it vary from court reporter to court reporter?
They have different rates. You know, they don't vary too much, but they typically charge per page.
Okay. I'm learning so many things. I'm one of those people that loves like legal TV shows and movies, and I eat them up. And so now I feel like I'm learning so many things that they're getting very, very wrong.
Yeah, there's a lot more that goes into it than we would assume from the juicy parts that are highlighted on our favorite shows.
Let's continue to talk about that. I want to hear more about what the entertainment industry, whether it's movies or TV shows or us authors, are getting wrong. But if you are joining us live and you have questions, now is the time to start sending those in. Please make sure that you are dropping those down into the comments. We had some written in early that we're going to be handling as well, and we're going to get to as many as possible while we are live on air today. But let's keep talking about what we're getting wrong and what we need to fix.
All right, so here's a situation that, just to pull an example, I don't know how many of you guys have seen the newer Netflix show Daredevil. So love the show, great show, but I have to say, I wish, and I don't know if they did this, but I wish they had KM's idea of maybe talking with an expert in the field before deciding on what your script is going to look like. There are a lot of situations in since it deals primarily, he's a lawyer, right? That's one of the main premises of the show here. And one of the things that drives me insane is, first of all, the number of cases they take pro bono. You've got to be a trust fund baby if you're going to be taking those kind of cases pro bono, and also maintaining rent in any kind of a New York commercial facility. So we've got that. But the other thing, the main thing that irritates me, especially in the criminal aspects that we're looking at here, someone gets arrested, and then 3 to 7 days later, they're having a trial. That never ever happens. It's not in Arizona and in any other case or any other state. It's not happening. You get arrested, you get charged. Typically within 30 days, you're going to have an arraignment. And that's basically where you show up to court, you are presented with the charges against you, and you formally enter a plea of guilty or not guilty. Usually you're saying not guilty. So that's the beginning. And that usually happens about 30 to 45 days after you are arrested. So we're not even talking trial. We're not even talking evidence or anything like that up until, before you've even entered your plea. The state doesn't even know how you want to plea at that point. So anyway, after you go to your arraignment, and again, this is in Arizona, typically there are 30 days after that we're looking at getting the first round of disclosure. Again, we're talking disclosure. That's kind of a legal term that we use to talk about what information is when we're exchanging information. We don't send documents, we provide disclosure. So that's some legal jargon to pick up on, I suppose. But anyway, the state has a duty to provide all of the evidence that they intend to use against the defendant within a certain time period. And that's going to vary by jurisdiction, and also depending on the severity and complexity of the crime. And it may be ongoing. There are also supplemental disclosures available as investigations are ongoing. They may have enough to arrest the individual at that point, but that doesn't mean that their investigation is done. They may still be serving warrants. They still may be conducting interviews with witnesses, and they may still be doing forensic evaluations on any kind of electronically stored information, or if you have blood or bodily fluid samples that they need to get back from the labs. Those are usually pretty quick. They can get those turned around in anywhere from 1 to 3 weeks with that, which in my opinion is pretty fast. But these are all the kind of things that we're looking at in a criminal case where, and again, the more complex it is, if it's a financial crime where maybe you need to go through volumes and years of bank records, or if it's embezzlement or a systemic, someone skimming money from their employer. These are things that you're probably going to have, volumes of documents that you're going to need to go through as an investigator and put the pieces together analyze it, and figure out how it all connects in a way that you can, the detective or investigator can work with the prosecutor to be able to build a compelling case. And this isn't something that just happens in 3 to 7 days. This is something that takes months and months. Now the defendant has a right to a speedy trial. It is a subject of legal debate what the definition of a speedy trial is. And I can tell you it's not less than 60 days.
Okay.
Yeah, there's the disclosure process. There's, it's not as quick as they would like us to think.
Right.
So there's absolutely no way that something like that is any kind of criminal case is going to trial. And again, it's not one of those things where you get the trial by ambush with a surprise witness who comes in. Defense counsel does have the right to interview witnesses. And, granted, there are some times where privilege will occur. And, people can also, if they think that they might end up being a co-conspirator, or if the information that they might end up having could incriminate themselves, the Fifth Amendment does allow an individual to invoke it in order to refrain from saying anything. They can't be compelled to give a statement that would subject them to criminal prosecution, basically. Again, some people end up playing a little bit faster and looser with this than, may actually be warranted in their specific case. But again, that's from an outsider looking in. Who am I to say whether that's the truth or not? So
this is fascinating. I am loving on all of these tips and all of the things that we should be aware of. And I feel like I picked up a lot of keywords that we need to be paying attention to as well. What else do we need to know?
All right. So this might be a fun little topic, jury selection. If you find yourself in a situation where you're actually in a jury trial, and just for reference, only 2%, if you're talking civil litigation, only 2% of civil cases that are filed ever make it to trial.
Oh,
okay.
Wow.
So 2%. And there are two different types of trials that you can have. You can have a bench trial where you try your case in front of a judge and the judge makes the decisions, or you can have a jury trial. And that's something that is usually decided on by the parties. There are advantages to having a judge be your trier of fact as opposed to a jury. A judge typically has better understanding of the law and how it's going to apply to certain factual scenarios. And you also have less of a risk of prejudice. So if there's something that's highly prejudicial, like maybe one of your witnesses has a background where he's been charged with some sort of sexual assault or some sort of crime like that you may be concerned a jury could discredit him because of that. You may have a little bit more faith that a judge can cut through that and determine that person's credibility based solely on the merits that they're presenting in court that day. So, those are things to think about too. If you're getting into a trial situation, are your characters are they involved in a jury trial, or are they involved in a bench trial where the judge hears it? Most of them are bench trials, and that's my personal preference too, because I'll just say juries are crazy. Juries do crazy things. And, I've had the opportunity to speak with them afterwards, and sometimes the analyses make sense to me, but other times there are things that they pick up on that I just think, how was that relevant? But it's, again, we always remember, 50% of the American population is below average intelligence on average. So, you decide, am I taking my chances with a jury, or am I going to go in front of a judge? So if you find yourself in a jury selection situation, you have a pool of jurors that's summoned for jury duty. It's somewhere around like 160 to 200 people that are that are going to be pulled in for jury duty when there is a trial. And basically they line up, everyone's assigned a number. They put you in the first, the first 20 chairs, and basically they want to know like what your name is. They want to know what your occupation is. These are the kind of things that we don't really get to know too much about our potential jurors, except their name, their age. Sometimes we get to know where they live. We get to know their occupation. We get to know if they have ever been involved in any kind of litigation before. And sometimes they will tell us, is there anything that would prevent you from being an impartial juror in today's case? Usually if the answer is yes, we're not interested in considering those people anyway, because why would we intentionally set ourselves up to someone who has a potential bias in the case already and is admitting it? So anyway, they just kind of go through, and each side ends up getting a number of strikes. And again, it varies depending on the local rules, but prosecution or plaintiff can go ahead and strike certain jurors, and then defense can strike certain jurors as well. So it ends up being a little bit of, there's risk in this though, because you may decide, I don't like this juror, I think they're going to be prejudiced against my client, or I just think that they're, based on what they do as a profession, I think they may not connect with my client, or they may be hostile to my client's situation. You can strike that person, but if you end up getting out of strikes, if the replacement who ends up coming on that, isn't so great, you may be out of luck. So there's risk involved with that, but it's always kind of a nerve-wracking process to see, especially if you have a juror that you think is going to be good for you, and the other side strikes them. That sucks, but they get to do it. So,
is there a set number of strikes you get, or does that vary by the different districts?
It varies by jurisdiction.
Okay, gotcha. That makes sense. Okay, what else do we need to know? We've got a little bit of time left, and I've got a couple questions I want to get to, but what else do we need to know that people are getting wrong that we really need to get right in our stories?
So civil litigation, as I've said about the criminal defense area, it's not fast. We all want it to be fast. We all, but civil litigation is slow. You're probably not getting any kind of a resolution in a civil litigation suit for about 18 months if you end up filing a case and see it through, through discovery, through, other means. But it takes a while. I have one of my cases right now has been, it's been going on for 5 years. So
wow.
It went up on appeal, and now it's back in the Superior Court. And maybe that's another good thing just to touch on, to give authors a framework here. There are different levels of courts, and I'm going to say what it looks like in Arizona because other states use different terminologies. Okay. So what is Superior Court for us is District Court in, I think, California. Okay. So it's just different terms, but it's something that if you're interested in writing about, or your characters are, find themselves in a court system or having to navigate the court system, just do your research and be aware to check as to what kind of a case is going to be heard by what court in your state or in the state that your characters are living and operating in. So in Arizona, we have city court or municipal court, which handles things from, minor parking infractions or, getting caught by a red light cam. Then we go up to justice court, which handles, a little bit more serious situations, criminal misdemeanors, that kind of thing. Then we go up to Superior Court, which handles some of the higher dollar value civil cases, so anything over $50,000, as well as felonies. And that is the top tier of original, and I guess I'll say originating courts. Okay, so anything in the state system that's separate from federal. So again, that's something else to be aware of. If your characters are navigating a court system Are they going to be in your state court system? Or are they going to be in federal court system? Federal courts, you can have drug crimes, those kind of things are very often found in your federal courts. Or if you end up, I'm familiar mostly with them in terms of trademark and copyright infringement claims, where if you have a federal, oh, you know what? My light just went off. Give me just a moment. Oh, there we go. We were too still. Okay. So yeah, basically, if you have a federally registered trademark or copyright, or it's a question of, there's multiple jurisdictions in play, you could find yourself in federal court to be able to initiate a civil claim. So those are factors to consider. And if you have any questions, feel free to reach out to me, and I can help try and figure out where your hypothetical scenario could reasonably fall. And sometimes there's not just one right answer. And this is something that we as attorneys have to deal with on a daily basis if we're going to be filing a lawsuit. Sometimes claims are appropriate in state court and also federal court. And we just kind of have to look at the different advantages and disadvantages as to what we think, or what judges we think are going to be more knowledgeable about our client's specific case. So that's kind of more into the art of law side, but still situations to be aware of. From there, you have appellate courts. So appellate courts, you get into a court of appeals when you don't like the decision or disagree with the decision of the underlying trial court. So a federal court is going to be a trial court. A city court is going to be a trial court. A justice court is going to be a trial court. Your superior court, your district courts, sometimes I think they're called precinct courts on the East Coast, I've heard, in one state. Point is, check your states to make sure that to make sure what terminology they end up using here. But those are all going to be your trial courts. Now, they can all of those decisions, if it's a state court decision, will get appealed to your state court of appeals. The state court of appeals, if you don't like the state court of appeals decision, it gets appealed to your state Supreme Court. Okay, and then that's the highest level that you can go within the state court system. Okay, so you've got your trial court, then you have your state court of appeals, and then state Supreme Court. So in federal court, you've got your federal district courts, and then you have, if you don't like the decision there, you can go to your circuit court of appeals. Okay, so here in Arizona, we're in the Ninth Circuit. If I get an unfavorable ruling in federal court, in my federal district court, and I want to appeal it, I would go to the Ninth Circuit Court of Appeals. And depending on the location and jurisdiction and where the judges are that hear this kind of case, I've gone all the way out to San Francisco to have to argue some of these cases. So wow. It may not necessarily be convenient. And again, that's something else to consider. If your characters are, appealing this kind of decision, do they have the means and the resources to actually be able to pay for their entire legal team to go fly out to San Francisco to argue a case, to not just argue the case, but prepare for it and do all of that? It's a lot. Then after that, you get the Supreme Court. So the Supreme Court of the United States ends up reviewing decisions from the district courts.
Okay.
So if there's an unfavorable decision in the district court of appeals, or the circuit court of appeals, that's going to be heard by the U.S. Supreme Court. Okay. And so that's how that structure works. And I don't have a great graphic to be able to point you guys to, but I know that they make flow charts and that there should be plenty of them available online if you just wanted to Google, hey, what does the structure look like, in case you're more of a visual learner, or it makes more sense to look at that representation that way.
That is really good to know. Okay, so on that note, you mentioned that sometimes this requires traveling and going to do all these higher level things. Just kind of give us an idea of how frequently that happens in your line of work. Do you do a lot of these higher level, court cases, or is it kind of more localized for you? Are you traveling around? What does this look like?
It's kind of a mixed bag, and it really depends on what are the cases that I'm working on right now and what are my clients' needs. One of the areas that I do cyber law, and intellectual property kind of has a nice intersection with some of the online defamation work.
Oh, yeah.
And yeah, so in those kind of situations, we may be dealing with harms that may not necessarily have occurred in the state where the plaintiff is located. In fact, we may not even know who it is that wrote something online because they have they have a handle. Maybe they posted it from a Starbucks or something like that. We don't necessarily know this information. So, it's one of those things where that may end up involving a lot of cross-state interaction. But it's rare for me to actually be traveling out of state to conduct that, just because it's not really cost effective for my client to send me out there, and especially in the era that we live in with electronically stored records and being able to just create electronic discovery. You can send voluminous files with a link, so it's not really necessary for me to go out there to inspect anything like that. But if we did have to end up arguing a federal case in the Ninth Circuit Court of Appeals, then I'd probably be going to San Francisco for that.
Gotcha. Okay. So as somebody who writes a lot of techie things, I have to ask this for me because now I need to know.
Yeah.
When it comes to things like the defamation and you have to figure out who a person is because they use their handle and they were at a Starbucks and whatever, what does this process look like? Because now I'm very fascinated.
Yeah. So this is an area of law that's that there aren't too many attorneys in the United States that practice this area of law. So it's still kind of a very specialized niche. Basically what you end up doing if there's someone who's written, we've seen, unfortunately, some really, really tragic situations where people's reputations have been just trashed because of, either a scorned ex-lover or, whatever the situation is. And even we look at how much this impacts companies. And where does everybody go nowadays to try and figure out if they want to do business with a company? They go onto Google, they go on to Yelp, they want to see, what other consumer experiences are. Well, in spite of having all these terms of use and terms of service that users are supposed to comply with, saying that everything is true and actually reflects a consumer experience, people don't always abide by that. So basically what you would end up doing in a situation like this, you need subpoena power in order to be able to discover who these, I'm going to call them John Doe defendants are, who are posting this kind of stuff. You may have an idea. And if you have an idea, that helps us, because then we can narrow our requests, and it just helps with the discovery. So there's a whole process you have to go through to try and figure out who it is that you're supposed to be suing. So in the meantime, you just have to use John Doe as the defendant. And so you're filing a complaint against John Doe. You may, later on end up, ideally you discover him, because you can't get a judgment against a John Doe individual. This was done, someone actually did it a few years ago, but if you're looking to remove content, like Google and a lot of these search engines are not going to take down content or de-index content against a John Doe defendant, because they want to know, has this person actually responded? Has this case been resolved on the merits? And when you have just a case that has been filed against a John Doe, which is a non-participant, because if he hasn't even participated enough in the lawsuit so that you know his name or her name, a lot of these search engines just say, we're not in the business of trying to decide what's true and what's false. We're going to defer to the court for that. But they don't think that just a default judgment against a John Doe is going to be adequate to really get into the truth of something. They don't think anything's been adjudicated on the truth. So they're not going to help you with that.
Interesting.
So, yeah, but we have tools that we can use that once you end up having your lawsuit, you can issue subpoenas to, again, subpoenas go to non-parties. So if it's, if they're using a handle, like a username, you can subpoena the website to say, okay, give me the information that's affiliated with this person. Usually there's going to be something there. If there's not, and you also want to know what was the IP address that this person used to be able to post this content. From there, you can usually backtrack the person either through email addresses. You can go further with subpoenaing the email address providers. You can also look at the internet service providers, whoever it ends up with the IP address. So there's a number of ways that we can backtrack this kind of thing and ultimately figure out who your John Doe person is who's saying nasty things about you online. But again, lots of paperwork, not cheap, and it takes a long time.
I was just going to say, I feel like this is one of those really long processes, right? Does it take like a very, very long time? Is it months? Is it years? Like, what does this look like?
It depends. Some of them we've been able to determine and discover in a period of months. But again, we're looking more along the lines of sort of like a 10 to 12 month period. More than likely it's going to be years, but with a lot of this information, you have to act fast because these companies, the internet service providers, they don't hang on to this stuff indefinitely. So you have to be fast. You can serve an electronically stored information preservation letter, letting them know that information that they have in their possession may be relevant to ongoing litigation and that they are under a duty to prevent spoliation of evidence. There's another term, spoliation of evidence. When you allow it, or when you intentionally allow it, or just through negligence or carelessness, to be destroyed, basically, or lost.
Wow. Yeah. Okay. I'm just going to be very honest. I'm going to be hitting you up later because I see how this can play into one of my future books. So we're going to be chatting
please
about
do.
This. I love this. This is fantastic. We've got a couple more minutes. I do want to get to a couple of questions, and then we're going to jump back in with anything else you think we need to know. So
all right, hit me
up. Danielle wants to know, what was the hardest part of law school?
Oh, goodness. So for me, the hardest part of law school was not really learning the material. The material, it was, a lot of it was very, cerebral and philosophical. I think the hardest part of law school for me personally was maintaining my sense of self and identity in a very highly competitive culture. There's intense competition among everybody there because all of the classes are weighted on a curve, and you don't, it's not a question of how many people are getting the material right. It's that the teacher has 3 A's they can give out. They have 7 B's they can give out. And it was all predetermined. And again, this was the structure back when I was in law school, and again, may not be the same for every single one, may have changed at this point. But there's a lot of pressure and a lot of tension between the students, and it's easy to get caught up in, I studied this many hours yesterday, I drafted my outlines for this many hours, and it's very easy to get caught up in that numbers game and get competitive with your other law students. And so I think the biggest challenge for me was really being honest with myself and saying, am I comfortable with the material? Do I feel like I have complete mastery of that material? And is that feeling being affirmed in my discussions in class with my interactions with my teachers and my peers? And that was kind of the check that I was giving myself to keep myself, on track. But I think it's easy to have a miserable time in law school, and I was trying not to do that. So
I feel like it's very important, especially since you spend so many years of your life doing it, to then get into the industry after already having a degree. So I feel like it's important to be aware of that. We had another great question come in. Can you explain some of the negotiation tactics or practices that you have found to be successful when you are working in litigation?
Yes, absolutely. So, and this is a good question because it brings me back to something that I was hoping we would get to touch on also. And, so only 2% of civil litigation cases end up going to trial. So guess what? That means 98% of them settle. So let's talk a little bit about settlement. So typically, people have a lot of different strategies as far as what they think is an effective settlement technique. Some people, and again, this is something that, this is another good point too, that is an absolute hard and fast line. Lawyers cannot enter into settlement agreements without the explicit authority of their client. That is a right that is held exclusively by the client. The attorney does not get to make those decisions for the client. So if a client has given us authority ahead of time and said, yes, I'll authorize settlement up to this amount or up to within these ranges of terms, then we can go ahead and accept terms that's within the client's expressed range. But never can we bind our client to a settlement agreement without having that kind of express authorization. So there's never going to be a situation where the client is like, I didn't know that you agreed to that. Or if they did, the attorney is committing malpractice and violating ethical rules, and your attorney's in trouble. So, but typically with settlement negotiations and settlement strategies, I'll be realistic with my client, and it depends. It depends so much on each scenario. Sometimes my client says, these are my deal breakers. These are the 3 things that, I am not going to budge on. And here's kind of another factor that's on my wish list. It'd be nice. I'd like it. See what you can do with it. But if you don't get it, it's not going to kill the deal. And so maybe I can include something like that, include my client's wish list in the settlement offer that I originally convey. And then, we can kind of play around with that as being the squishy factor. So that's one of those things where I found, though, that typically trying to determine whether the other party is truly negotiating in good faith and actually wants a settlement resolution is one of the, if you figure that out, if you want to work out a deal, you're going to work out a deal. Usually, in those kind of situations, I'll go back and forth twice with them. My initial offer, and then, okay, here's my final offer. And if it doesn't get resolved within those first 2 offers, it's probably not going to happen. Very, very rarely do we end up seeing resolution if it goes back and forth all day. Never going to say never, because it's happened. But if I had to generalize and say as a rule of thumb, usually if it doesn't resolve within 2 offers, it's not resolving. And there's no point in wasting the client's money or time trying to continue on with that path.
That makes sense. That makes a lot of sense. Okay. All right. So then we've got another great question that came in. Oops, and I definitely just moved it. There we go. Is it easier for you to work with a team of lawyers, or do you prefer to handle clients on your own, just generally speaking?
Well, it depends. Typical lawyer answer, right? It depends. With civil litigation cases, these are typically handled with a team of attorneys, and not just attorneys, but also with support staff. So I will have assistance from my legal assistant, and I will have assistance from my paralegal. And and if I can handle the case with just those 2 other individuals, great. But typically there are 2 attorneys that are assigned to the case, and I think it helps just with collaboration and case strategy, because I'm not going to sit here and come and say I know everything, and I'm certainly competent, and I'm going to do a perfectly fine job on my own. But it never hurts to bounce ideas off of another experienced and esteemed colleague, because they may have other ideas. They may say, hey, there's this one time I tried this worked. We've not any one of us has seen it all. And I think that, if you can work with a team, you end up getting a little bit more of a collaborative bonus than you would if you were just going to try and handle it on your own. Now, if it's something more along the lines of like a trademark application or copyright registration or things like that, those might be things that I would want to just handle on my own, because I can just do a deep dive into the mark, into the property that needs protection. And it's easier for me to just be the one who works and focuses on that. And I don't really, it's a contained enough world that I don't really need or want anyone else getting involved.
That makes sense. Okay, so real quick off of that, I do want to ask you to just give us like the keywords, the buzzwords, the titles for this. I know you work with teams and people who work with you and assistants. So what do we need to know to Google these later to see who all does what?
Yeah, sure. So attorneys, we sort of fall into different categories. You have associate attorneys who typically do a lot of the work that the shareholders or partners will give you. And those words can be used kind of interchangeably, depending on the corporate structure of the firm. So, but we're all attorneys. You would call the attorneys working on your side, your legal team, or if it's litigation, maybe the litigation team. Those would all be appropriate terms to use. Paralegals are certified. They have certifications, and they are typically qualified to work on, drafting things that may not necessarily need like a legal analysis, but maybe it's a request for a continuation of a hearing. Oh, and that's another good term to use also. Hearings don't get like extended or recalendared or things like that. They get continued. So that's if something is rescheduled from one day to another day, it got continued. So another trick of the trade. So legal assistants then will work on like case management, like document preparation, like organizing the case file, perhaps preparing correspondence for the attorney's review and signature. So those are some of the different duties that are laid out.
Perfect. I love it. We're going to Google all of these things later too. One more question I do want to touch on. They do want to know, what are some best practices for protecting one's intellectual property, since you do a lot of work in that area?
Right. So intellectual property falls into 4 different categories. We've got patents, we have trademarks, we have copyrights, and trade secrets. So patents are used to protect functionality and utility, things that do something like a process or an invention. Trademarks and copyright are probably what's going to be most relevant to the creative and artistic world. Trademarks are used as a source designator to denote the source or origin of goods or services. So, like the Nike swoosh sign is a trademark. You can have anything that's a picture, a phrase, a slogan, a sound, like a jingle. Any of those things can be used to designate, as long as it's working as a trademark, which is to designate the origin, like a common origin of a good or service, is functioning as the trademark. Copyright is the creation of any sort of original creative work. And a lot of people, one misconception out there is that in order for a work to be protectable, there has to be some kind of percentage that it is changed by. That's not correct, and there's no case law out there that says that. If you happen to find one, please send it to me, because I've never seen it. But basically, your change to any sort of copyrighted material needs to be significant enough to be able to constitute an original creative work. And I know that's kind of vague, and yes, it is vague, and it's also the subject of a lot of legal scholarly debate. So it's something difficult beyond the scope of this talk that I can go ahead and define. But yeah, if you want to protect everything, get it registered. Register your copyrights with the United States Copyright Office. Register your trademarks. Those are going to invoke federal protection for you and open up a whole lot of new rights to you that you wouldn't have with unregistered copyright and unregistered trademarks. You can also register some trademarks within your state Secretary of State system, but again, those aren't going to give you the same strength of federal protections as you would if you registered it with the United States Patent and Trademark Office. So when in doubt, register, and I can help you with those kind of things. And if you want to hit me up and tell me you saw KM's video, I'm happy to offer you guys a friends and family discount too.
Thank you. That is so sweet of you. I love this. This is fantastic.
No problem.
We are coming to the end of our time. So is there anything else we need to be aware of as authors about being a lawyer?
I think this just about covered it, aside from any more specific questions that you guys end up having. If anything does come up, or if you have a scenario that you're like, hey, I'm really not sure how this would play out, hit me up on email, shoot me a phone call. My email is mmozdezen@maypotenza.com. And you can find me on our firm's website, www.maypotenza.com, MAYPOTENZA.
And we will link those in the show notes on the replay as well, so you can find them down below, friends. My friend, thank you so much for all of your time and all of your wisdom and knowledge today. This has been fantastic, and I cannot wait to reach out to you about some of my books, because you have just triggered all sorts of ideas in today's conversation. And thank you for letting us know where we can reach out to you. Any final thoughts before we leave you?
No, I'm just happy to be a resource for everyone, and if I can help you in any way, please don't hesitate to reach out.
Wonderful. Well, thank you so much for joining. I do appreciate it. If you are watching on our live stream or our replay, we are not done yet with our Experts for Authors series. We do have a martial arts expert coming up next. I'm so excited. So bring all your fight scene questions. This is happening in the next week or so. We're nailing down a date, so we will keep you posted inside of our group. You can join us at experts.kmrobinsonbooks.com for more and to get your questions answered in real time during our live stream Experts for Authors Q&A sessions. Thank you all so much for joining. We will see you during our next live stream. Until then, have a great day and stay inspired.